Welcome to K-Talk. This is lesson number 7. I'm Dan O'Gorman, Associate Professor at Barry University School of Law.
And I'm Steve Maxwell, Director of Academic Achievement and Lecturer in Law at University of Miami School of Law.
And this lesson continues our discussion of the formation of a contract. Today, we're going to talk about contract formation, specifically termination of the power of acceptance. Steve, I love this topic because when I think of sort of nasty contract formation issues, I think of this back and forth between the parties. And so I think of a lot of things happening like counteroffers, somebody makes a rejection, they renew their offer. Is it fair to say that when you think of maybe a bar essay, it's possible you could see a lot of this going back and forth and the student having to figure out whether the offeree still has the power to accept the offer?
Absolutely. And I get this image too. This termination of the power of acceptance is kind of the departure from our ongoing tennis analogy, because you can't, in tennis, you can serve, but then you can't like pull the ball back. And so this is like the first departure from that analogy where it doesn't quite work.
It's true. You've got me now thinking about what are these events, and I will put the next slide and our only slide of these events that are going to terminate the power of acceptance. I'm now trying to imagine what each of these 6 would be in the tennis ball analogy. So we'll see if maybe we can make this work and keep the analogy going. Because I guess
the first one, I think it does work. If you serve and then you drop dead.
Sadly.
Yeah, right.
Yes, that one does work. That one does work. So termination of the power of acceptance. This is the way the restatement talks about it. A lot of people talk about it as termination of the offer. And so a lot of people, when they see, well, what do you mean termination of the power of acceptance? And if you said to them, well, talking about termination of the offer, they might go, oh, okay, I get it. Steve, it doesn't matter how you phrase it. To me, this is semantics. I like termination of the power of acceptance as the phrase because that's what the restatement uses and it makes sense to me. But if you want to talk about it in terms of termination of the offer, go for it. It means the same thing. And what we're talking about now is what happens when the offeror makes an offer. We know that the offeree gets this so-called power of acceptance, often called also the power to form a contract. And some events can happen where the offeree loses this power. I mean, if you think about it, like you've got a power, I guess one of 3 things happens, either any power, I think, the offeree the person exercises the power and therefore, gets the benefits of whatever it is when they exercise that power. They either don't exercise that power, and I guess it just sits there dormant forever, or some event happens to take the power away from them, to extinguish it. And we're now going to talk about these events, which once the offeree has this so-called power of acceptance, there are 6 events that could occur to take away from the offeree their power of acceptance. And if it's gone, then the offeree can no longer say, I accept and form a contract. They can say, I accept, but it wouldn't form a contract. It would actually be a counter offer. And an important thing we're going to talk about with these events is when are they considered effective? Because remember, as we talked about with acceptance, we know when acceptance is effective. We know that when it is a bilateral contract and you are negotiating at a distance, we have the so-called Mailbox Rule, aka dispatch rule, which is effective upon dispatch. We know when it's in person, it's when you say I accept, or if you're on the phone, it's when you say I accept. We know with unilateral contracts, it is when the offeree completes performance. That time period when an acceptance is effective is almost always going to be in play when you are comparing it to one of these 6 events. And which one happened first? Which one was effective first? It's kind of like, who cares about one without the other? If you're talking about effective time of acceptance, I think you're almost always saying, well, one of these events here on this screen that terminates the power of acceptance must have happened. So we're trying to figure out which one happened first and was effective first.
And with respect to that order of the communications and the events in the fact pattern, when you're writing an essay on contract formation, it encompasses all of these different communications and events that are happening during the formation process or non-formation process, whatever the case may be. It's really important to structure your essay in chronological order. A lot of students don't think about how to put their essay together when they're learning an area of law. And I just want you to be thinking about this as, if the law thinks the sequence of events is important, then your essay should conform to that importance and should be structured sequentially. If this is a bar essay, and even I think a law school essay, you would want to organize it like May 31st communication, June 5th communication, and analyze each of the communications in the order in which they happened in the fact pattern, where that legal significance is important.
I used to equate it with like a director's cut of a DVD of a movie, where you're explaining, and then this scene we did this, and then in this scene we did this. Now I wonder if maybe it's more like a reaction video. These reaction videos are so famous, where people go onto YouTube and they watch a movie and they show you their reaction. But so it's a little bit like a running commentary, isn't it, on the events as they happen?
Yeah, absolutely. And I like that. That's a good analogy. It's like, you're observing the events between the parties and just commentating on it as they unfold. I think that's absolutely right. And keep that kind of structure and that voice, unless your professor tells you to take a position of one of the parties, and then you might be able to change that voice a little bit.
And well, of course, we're going to have to do a video at some point on time management, because I found one of the things that students struggle with, of course, with that approach, which we are recommending, is you got to move fast. You can't, it's very easy to get bogged down too, right? If you spend too much time commenting on each event, right? I assume you've got to, move fairly quickly through those events, which can be a challenge.
Absolutely. Always. There's always a bit of a time crunch.
Absolutely. So if you feel there's a time crunch, that's probably a good thing, because you're seeing a lot of issues. If you walk out of a law school exam, you're like, wow, there was like so much time and so little to write about. Probably bad news. All right, let's talk about these famous 6 events, which will terminate the power of acceptance. And remember where we are. An offer has been made. The offeree now has the power of acceptance, and we are now assuming they have not yet accepted the offer. And we're looking to see if any of these 6 events occurs, and thereby they lose the power of acceptance. And so they can no longer form a contract unless, of course, the offeror revives the offer or the offeree makes their own offer. So the first one is death or legal incapacity. And this is the death of either the offeror or the offeree. And I do want to note that some of these events are not going to terminate the power of acceptance. There's something called an option contract, which we will have a separate video on. So just keep in mind, when we're talking about these 6 events terminating the power of acceptance, we're assuming there's not something called an option contract, which is an irrevocable offer. Again, we'll talk about that on another podcast. Okay, so I think death and illegal incapacity, that's pretty obvious. Some of these events are going to be interesting because it's not going to be clear if these events have occurred. Was that communication or revocation? Has there been a lapse of time? How long is too long? Death or legal incapacity, not hard to understand. Death, certainly not hard to understand. When we talk about legal incapacity, we are talking about a situation when the offeror or the offeree has been declared mentally incompetent by the state and had their power to dispose of their own property, including contract, taken from them and given to a guardian. So we're not here talking about things where you might have capacity, but it's partial, like being a minor or having a mental illness, but you've not had the power to contract taken from you by the state, or intoxication. These are generally just partial you still have partial capacity, and it's like you only have partial incapacity. We're talking about legal incapacity. We mean it's been stripped. Your power to contract is just gone. It's been taken from you by the state. So this goes to the offeror or offeree. So Steve, I make an offer to you, and I'm now seeing, I feel like I'm serving the ball. I make an offer to you, and the ball is in your court. And before you accept, I guess accepting would be what? Hitting it back over to me?
Right. I think so. It would be a return.
That sounds fair to me. And right as you're ready to do that, I drop dead. So your power, you can return it if you want, Steve, but it's going to be of no legal effect. The game, Steve, is over.
So I can come to the funeral and come up to the coffin and say, I accept. And that is a nullity.
That is definitely a nullity. And this is what's, and obviously, if you die, you can't accept. Now, this is a little bit more obvious, because how do you return the serve if you're dead? So the fact that the offeree dies, you lose the power of acceptance is, of course, not surprising, because the power of acceptance is personal to the offeree. So usually, I think what we're talking about here, if you're going to see this on an exam, I think typically it's probably offeror death. Mm. But here's what's interesting about death and legal incapacity is that the power of acceptance is lost for the offeree the minute there is death or legal incapacity, even if the offeree was not aware of it. So I serve the ball, and you are looking down and you just return it, because Steve, you're so focused on hitting it, because you know what a good tennis player I am, right? And how fast that serve is coming in. You're just paying attention to the ball, as you should. You have no idea, Steve, that I have died, that I am laying there when you hit it and you return it. There is no contract formed, because death or legal incapacity terminates the offeree's power of acceptance immediately, even if the offeree didn't know about it. And the reason why this is significant is because this seems to go against most of what we see in contract law, which is our objective theory of contract, which is what would a reasonable person believe. And even if the offeree has no reason to know that the offerer has died, it was totally unexpected, the power of acceptance still terminates. So even though I don't like this phrase, meeting of the minds, because it suggests a subjective theory of contract formation, which is not the law, here it seems like we've got a holdover of this old meeting of the minds concept.
And it's a departure from that rule we talked about a few sessions ago, where the mailbox rule is the oddball that's effective. Acceptance is effective when dispatched, and everything else is effective when received. But death seems to be one of those that doesn't even need to be received or dispatched. It just has to happen.
Exactly right. Just has to happen. So the way you will see it oftentimes, and is in play maybe with something like the mailbox rule, because remember, we're comparing the time of acceptance when it's effective against the effective time of one of these events. So if the offeror sends an offer to the offeree receives it, offeror dies unbeknownst to offeree, and then offeree mails the letter, no contract, because the effective date of terminating the power of acceptance was prior to the effective date of acceptance, dispatch. If, however, offeree dispatches the letter, and then while in transit before it's received, offeror dies, contract, because the dispatch occurred prior to the death. So note how important it is to recognize when acceptance and termination are considered effective, and then compare the two and say which one happened first. Okay, on to revocation. So students often confuse revocation and rejection. And you want to remember, revocation is an act by the offeror. Rejection is an act by the offeree. And I understand students have so many legal terms swirling around in their heads, but you want to try to keep this separate. So offerors revoke an offer. So two things tend to be important about these events. when are they effective? And how do you know if it's happened? Well, death or legal incapacity is pretty easy. Revocation, and it's got the interesting part about effective upon death, not notice. Revocation, back to a receipt rule. Like you had mentioned when we talked about acceptance, dispatch rule is sort of the odd man out. Just about everything is the receipt rule. We've seen one other exception now, death, but the general rule is receipt. So I think when in doubt, go with, if you have no idea, I guess if I was a gambling man, go with receipt rule.
Right.
I guess. Though it seems like us, we professors like to ask a lot about the mailbox rule. So maybe that's not a good bet. But revocation is not effective until receipt. So for example, let's use the dispatch rule again as an example. And not death, but revocation. Offeror mails an offer to the offeree. Offeree now has the power of acceptance. Offeror, the next thing that happens, offeror mails a revocation letter revoking the offer. Revocation is a withdrawal of the offer. So you kind of like got a string on the ball in tennis. You let me know if I'm taking it too far as an analogy. And
no, I like this.
You like
I would have never thought of the string, but I like that because
it's like paddle ball. It's like
right.
pulling it back.
The yo-yo.
It's like a yo-yo. I'm pulling it back. And so the revocation is a withdrawal of the offer. You're taking it back. And the good news for the offeror is the general rule is the offeror, right, can always revoke an offer. Again, an exception, big asterisk, is something called option contracts, but we're ignoring option contracts for this session. General rule is offeror can always revoke the offer. Even seconds later, there is no requirement that the offeror give the offeree a certain amount of time to consider the offer. Look, it was your offer. You gave it. You want to pull it back? Go for it. But the problem is revocation is not effective until received. So we know with the mailbox rule that acceptance is effective upon dispatch. So if I, the offeror, dispatch a revocation, I'm taking a big risk here, because I now know that the power of acceptance for the offeree is not going to terminate unless and until the revocation is received by the offeree. And if prior to receiving the revocation, the offeree dispatches an acceptance, then we have a contract, assuming the mailbox rule is in play, because the effective time of acceptance beats the effective time of revocation. So it behooves an offeror who wants to revoke an offer to do everything they can, it seems to me, to get notice of that revocation to the offeree sooner rather than later.
Now, I don't want to muck this up because I have a tendency to muck things up. But when the revocation is received, is the effective time. When is it received? Is it when it hit the offeree's mailbox, or does the offeree have to actually open it up and read it? Can they put it on the counter and look at it next week? When does that happen? Because I remember being so, there's just so many sub rules with these things.
Yeah, there certainly are. And it's funny, I think one of the prior podcasts, he said, the staters seem to have thought of everything, which I'm sure they would smile, if they'd heard you say that. And they thought of this one too. So receipt, we do have a definition of received. Received, of course, is when it is, you actually become aware of it, but it doesn't have to be that. Received includes delivering it to a place where the offeree ordinarily receives communications or has designated as a place to receive it. So the minute it hits the offeree's mailbox or is delivered to a place where the offeree ordinarily receives communications, that is considered received. So received is not the same as knowledge. Received can include a situation where the letter has been put in your mailbox, but the offeree is on vacation, they're at the movies, they're not at home. That is considered received. Because otherwise, if you think about it, then the offeree could avoid it. Oh my gosh, that could be a revocation. Don't read it. put it away, burn it. So yes, so that is our received rule, is when it is placed, it received at a location that the offeree ordinarily receives their things. And there's a definition of receipt. I could bore you with it, or I could say, really, you should just buy my book, right? And figure it out. So, oh wait, hang on, here it is. Received. A revocation is considered received when it comes into possession of the party or a person authorized by the party to receive it, or it is deposited in a place authorized by the party as a place for it to be deposited, or similar communications to be deposited. So yeah, so
Okay.
Yep, don't have
So
to
that's like
actually.
a parallel rule, like when, mailbox rule is when it hits the mailbox to be dispatched and the moment, but the receipt rule is similar. When it hits their mailbox, it's received.
I like that. So it's like, that makes a lot of sense to me. So the mailbox rule is when you relinquish possession, and receipt is when you have possession, but possession is, I assume if the cops break into my house and, sitting in my foyer, are some drugs in a package, my guess is arguing I didn't have possession of it. I'm not a criminal lawyer or a criminal defendant, fortunately.
Right.
Right. Never convicted, never convicted. Do you remember what movie that's from?
Oh gosh, no.
Stripes. You were there. They're signing up for the army, and he says, "Have you ever been convicted of a crime?" And I think one of them says convicted, and then like Bill Murray says, "Never convicted." So I assume the argument, hey, I don't have possession, it probably isn't going to work, would be my guess.
Yeah. It strikes me as a bit of a technicality.
Yes. And so I like that. So yeah, so it is sort of the opposite of the mailbox where you relinquish possession. Here you've got possession. It's considered received, even if you're not aware of the contents. So a revocation is a withdrawal of the offer. But here's where things get fun. The question is, what happens when you have a communication that you're not quite sure if the offeror is intending to revoke? I mean, we live, right, in contract law, we live with ambiguous, the grist of the contract's mill are these ambiguous comments. And what does it mean? And not surprisingly, here we are going to apply, just like we would with, hey, is that an offer? Hey, is that an acceptance? We are going to apply the objective theory of contracts. What would a reasonable person believe? So a revocation is a manifestation of intention to withdraw the offer. The question then becomes, okay, would a reasonable person believe from excommunication that that person was intending to withdraw the offer? And, there's a case that I teach where the offeror says during a conversation with the offeree, something to the effect of, I'm not sure we want to go through with this deal. And the question is that a revocation? It's equivocation is what it is. And I love this because, as you may recall from acceptance has to be unequivocal. That's the Blackletter. To be an acceptance, you got to know that they want to be in. Well, now what happens when the offeror, having made an offer, they equivocate? Is it sort of the same doctrine that now, like, since an acceptance has to be unequivocal, equivocation by the offeror now collapses everything, and that's a revocation? The restatement says, it depends. Tell me more. I love it. Joe Perillo, a famous contract professor, says equivocation, a reasonable person would think you're out. The restatement said, it depends, it could be. And I kind of like the restatement because the restatement recognizes that it's very hard to construe language outside of its context. Okay, equivocation. Well, there's equivocation. So would a reasonable person believe that the offeror is not, I got to be careful here, not interested in going forward with the deal? Or would a reasonable person believe that they are probably not interested, that they have cold feet, I'm going to give you the definition. Okay. So a revocation is the offers a withdrawal of an offer. That's what I write. That's not very helpful. Any clear manifestation of unwillingness to enter into the contract is sufficient. So I don't know. So I think that can be very debatable at times, whether a particular equivocation is a reasonable person believe the party is expressing an unwillingness to go forward with the deal.
Yeah, that definition doesn't seem to encompass those occasions where the offeror just, I'm not sure if this is a good deal. That it sounds like they're still willing to do it. They're just not liking the deal that they've offered. And so it's, I don't know if that definition is very satisfying.
It is, and maybe I'm to blame because I wrote that in my book. So, so Lori, if I recall correct, I think Lori on Shark Tank had made an offer, and she then at some point said, the guy's talking, he's trying to get other deals, I guess. And she says, you're making me nervous because he wasn't doing a good job. And I always wondered, when she said, you're making me nervous, would a reasonable person believe she was now revoking her offer? I mean, I will tell you this. It seems to me that if you have reason to believe that the offeror is no longer giving you the power to accept, then it's a revocation. And I know that's not very helpful, but it seems strange that I should be able. So the power of acceptance is given to you as the offeree when a reasonable person will believe that the offer is ready to commit, right? The ball is in your court. I'm in if you're in. One could make the argument that any reason to believe that the offeror is no longer at that place, is pulled back from that, should be enough. I mean, if you needed that to get the ball in the court, couldn't you make the argument that if the reasonable person believed that the offeror was no longer there, that's a revocation? But on the same hand, I know I've given you a power of acceptance. If I'm going to pull back from that, maybe we would expect the offeror to be more clear about that. I mean, I know after I've made an offer, isn't it reasonable to believe that I'm pretty clear now that I'm pulling it back? But so this is sort of the grist for the contract's essay mill. You've got some sort of equivocation, some sort of indication of potentially cold feet. Would a reasonable person believe that the offeror is manifesting an unwillingness to go forward with the deal? That's gray, probably. Include competing arguments.
Right. This is kind of one of those red wire, blue wire situations where you've just got to show your professor that you see both sides of the argument here. And it, this is one of those times where I'd want to port a rule from somewhere else in contracts, but this is reminding me, and I don't want to jump ahead, but this is like reasonable grounds for insecurity, where I would love the offeree to be able to say, are you still in or not? And then have that answer or lack of a response be binding on the offeror. But I guess there's no such analogous principle. This is just where you're going to argue that this was a revocation or it wasn't a revocation.
Well, no, that's a very good analogy. And, so we do have, when we talk about repudiation, we'll probably talk about this concept that if you think the party, the party repudiates a contract, then, your duties are discharged, you can terminate the contract. But there's these times where you have this ambiguous statement. You're not sure. Maybe something's happened or a party's made a statement that's ambiguous. They're indicating maybe cold feet, but they're not being clear that they're not going to do it. It just looks like they might not do it. And that's, as you mentioned, that's called reasonable grounds for insecurity. And it is analogous. So you have reasonable grounds for insecurity as to whether the offer is still open. Something strikes me as it's unsettling that if you get reasonable grounds for insecurity that you can then snatch up an offer. I really think contract law is not supposed to be a game of gotcha. And something does bother me about this idea that if you're getting information that suggests they may not want to go forward with the deal. Yeah, we might not want to do that deal. I accept. Boo. You know, really? I mean, that's just something, you know, stinks about that to me. But there's certainly no requirement. There's never a requirement to demand. The demanding reasonable assurance rule with repudiation is actually there for the protection of the promisee. Here, what's happening is once you get a whiff of reasonable grounds for insecurity, the offeree could potentially, they may not want to ask, right? If they may just want to say, I accept. And so if they actually ask about it, it could avoid a lot of confusion, but they also might not get the answer that they want. So keep that in mind, that whether a reasonable person would believe a communication is a revocation can be debatable, and it can be gray, and don't panic about that. I mean, you see that on essay, make competing arguments. Every time you're trying to interpret language and the language is ambiguous, this is an opportunity for you to do that red wire, blue wire business. Something else to mention with revocations, we have something called a direct revocation, which is what people would typically think of as a revocation, which is when the offeror communicates to the offeree an unwillingness to go forward with the proposal. And you don't have to use the word revoke. So I don't want to go forward with this deal. That offer is off the table. Those are all clearly revocations. There's also something called an indirect revocation, which is when the offeree receives information from a reliable third-party source that the offeror has taken action inconsistent with a desire to enter into the contract. And when this is, for example, what happened where the offeree has been offered property that the offeror owns. And then the offeree learns from a reliable source, maybe a real estate agent, that the offeror has just sold that property to a third party. The offeree has acquired reliable information that the offeror is no longer interested in going forward with the deal. I mean, they have one parcel of land, and you've learned they've sold it to somebody else. It's reasonable to believe the offeror is no longer interested in entering into that deal with you. That also is a revocation. We call that an indirect revocation. So watch out. Not all revocations come directly from the offeror. They can come from a third party. And of course, you can have a lot of fun with that one too, which is, well, I've heard that the offeror is offering that land to, or considering offering that land to third parties. Is that enough? Well, I don't know. Now that's debatable. But so we call that an indirect revocation.
You know, something I think bears mentioning here at revocation, because I think it's a very popular issue to test on by professors. And so it's important to keep in mind that if you do determine that the offer was effectively revoked, now you have an essay issue where, oh my gosh, what do I do for the rest of the essay? If the offer was effectively revoked and I conclude that, now I've got a lot of other things to talk about that I see in the facts. How do I keep writing when the offer was revoked? We have no contract. It's important to keep in mind that if you conclude that the offeror effectively revoked the offer and that therefore there is no contract, you want to write in your essay, but if a court found the revocation was ineffective, then the next issue is, and continue to analyze those issues that you see in the fact pattern. Because, you know, if you shoot the contract down at the beginning, you may be missing a lot of points for analysis of further issues down the chain.
So in other words, even if you decide, when you're talking about red wire, blue wire, and if people haven't watched prior episodes, they don't know what we're talking about. And I'm not going to tell you because you should go back and listen to those episodes. So the red wire, blue wire, you then, if you decide it was the red wire is the right wire to clip, but that would bring an end to everything. I don't know, is it blowing up or not blowing up? You should then also discuss what would have happened had you done the blue wire, the other wire, in other words, and run that story through. That it's kind of like I love the show Communion, and I'm sorry, Community, not Communion. Was that a movie? Community. And community, they have this thing where they have different timelines that they order a pizza, and the pizza guy comes downstairs. He rings the bell. They're in an apartment building, and they roll a die 6, to decide who is going to get the pizza. And they believe that they've created different timelines. And in one timeline, it was a 1, and somebody went and got it. And so different things happen. It's like the butterfly effect, different things happen then. So 2, they have these 6 different timelines. And so that's kind of what you need to do with your contracts essay, right? It's have these different, not really timelines per se, but sort of in the sense that community was talking about it, right? What would have happened if this was what would have happened, different legal timelines, so to speak. All right, let's talk about the next one, lapse of time. So the law could have said that if I make you an offer and you have the power of acceptance, that you have it in perpetuity until one of these other 5 events happened, but the law chose not to do that. The law chose to have a shelf life on offers. Now, lapse of time, the first thing you want to think about is, did the offer specify a shelf life on the offer? Students often forget this. Students often want to jump to the default rule, which is that if there is no shelf life specified by the offeror, then the offeree has a reasonable time within which to accept. After a reasonable time passes, the power of acceptance terminates. They always want to jump to that. If I go into class and I say, well, how long does an offeree have to accept? Everyone shouts reasonable time. They always jump over the first thing to look at is, did the offer specify a time limit? The offeror, as the so-called master of the offer, can always specify a time limit, and that time limit can be longer or shorter than what would otherwise be a reasonable time. And if they have specified a time limit, that's the one that controls. So let's say, Steve, that I offer to sell you some land. And let's say in our local community, a reasonable time to leave that offer open or to accept is 2 weeks. If I tell you you have 2 months, under the lapse of time rule, your power of acceptance isn't going to terminate for lapse of time for 2 months, even though that is longer. And if I told you you have 24 hours, your power of acceptance would terminate through lapse of time after 24 hours, even though it is shorter. So always look first to whether there is a shelf life. It's sort of a bit, and this is not a revocation. A lot of students want to talk about when the offeror puts in a shelf life, you have 2 weeks. They say, well, the offeror revokes it at 2 weeks then. Not really. That's a separate doctrine. Revocation is when the offeror actually does something or says something after the offer to then terminate the power of acceptance. They withdraw it. Lapse of time is sort of a built-in revocation for those people who are like, oh my gosh, I may forget. I better build in as protection and a revocation, but it's not technically a revocation. It's under the lapse of time rule. Here's one I like, Steve. What about this? I mail you. See, it's a shame snail mail doesn't, no one uses snail mail. All these great issues with snail mail. I mail you an offer letter, and I tell you, I just say you have 6 days to accept. I don't say 6 days from when. I don't say 6 days from the date of this letter. I don't say 6 days from receipt. I just say you have 6 days. That's a good one, right?
Yeah, that's a great one.
You like that? So this was a case actually, Caldwell versus Klein. And the court said, and we take this as our general rule, that if you just say an amount of time, it generally starts running upon receipt of the offer, because until received, it's not an offer. Remember, offers are not effective until received.
That's a great reason. This is why wise people make these decisions.
Well, you're a logical guy. You like the logic of it. Some people be like, well, that's too cute, right? It's too logical. Really?
It is. I won't lie. It is adorable.
It is. It's one of my favorite little Blackletter contract doctrines. It is an interesting one. So, okay. So now let's get to what is more the lapse of time rule that people think of, which is the offer hasn't specified a shelf life on the offer. And as we know, the rule then is that the offeree has a, quote, reasonable time within which to accept. And of course, what you're saying is, what's a reasonable time? Steve, I have no idea. How do I know? So well, this is what we do know. A reasonable time is the amount, it's not going to be helpful. The amount of time that a reasonable offeree would believe was acceptable to the offeror. Context matters here. So if it's an offer for an item where there is rapid fluctuations in it, like the sale of a commodity or securities, the amount of time is going to be considered much shorter than something else. If you have a history of dealings, then you can look at those to help figure out what you think would be reasonable. But I think the way I like to think of it is, when is it reasonable to believe, at what point in time, that if you've not accepted, the offeror is going to move on and do something else with their life, contract with somebody else? And again, can be very debatable. It is, what does reasonable mean? So a lot of times a lapse of time issue on an essay can be very debatable. And again, you're dealing with that red wire, blue wire issue. It's debatable.
And it seems like you could go to any fact in the fact pattern to look for the reasonableness of that time period. The nature of the product. If we're talking about an offer to sell you bananas, that bananas will go bad in a couple of days. You probably, a reasonable time is not very long. But if it's something more durable, maybe that time is quite a bit longer. I would think industry standard might be at play there, or just almost anything that bears on the reasonableness of that time to accept.
Absolutely. And one thing we know is, if the offeror is in fact, we believe the offer was in fact okay with the amount of time taken, then there is no lapse of time. And this happens sometimes where the offeree accepts, looks kind of late. Maybe it's beyond what we typically think is a reasonable time, but the offeror receives the acceptance and then starts preparing to perform. And then a couple of days later says, oh, wait a second. No, I want out. Well, if a reasonable person would believe that the offer was in fact okay with the amount of time, that will be considered a reasonable time. And you can often show that by showing that the offeror was engaged in these actions to perform.
Yeah, and that makes a lot of sense, because my gut's telling me that lapse of time rule is really there to protect the offeror, not the offeree. And so if the offeror seems cool with that amount of time, who is the court to protect them further than they've manifested a sense of protection of themselves?
I agree with that. It reminds me a little bit, I think modern contract law, and I don't know, that rule may be old, I don't know, about, that the offeror is okay with it. But, modern contract law a lot of times takes the position of, what's the problem? If there's no problem, let's not create a problem. If everyone's okay with it, let's go with it. If both parties think X means X, we're not going to say X means Y, because a reasonable person would think that. So modern contract law is very much, I think, about, look, if no one would seem to be unhappy with it, we're not going to stir up trouble. The reasonable person isn't going to come in, and the reasonable person in modern contract law is not there to cause problems when there weren't problems. If both parties were okay with something, the reasonable person in modern law is okay with it. Like, no worries, I'm not getting involved. Whereas maybe more old school was the reasonable person would show up and be like, what's wrong with you people thinking this? Well, we both thought it. Yes, but that's wrong. I see a lot of finger wagging in old school contract law. The reasonable person doesn't, if you both are okay with it, the reasonable person's like, hey, live and let live. On to rejection. So the offeree, oh, and notice I want to mention something about revocation, lapse of time in connection here. As we talked about, the offeror in general retains the power to revoke their offer. This is true even if they've given a shelf life, even if they've promised to keep it open. This is our general rule. So if I tell you, Steve, you have 2 weeks to accept this offer, that does some work. We know now your power of acceptance will not terminate under lapse of time for 2 weeks, unless I come back and shorten that time, which I can always do. But as a general matter, that doesn't mean I can't terminate your power of acceptance in other ways, such as revocation. So if I tell you, Steve, you can have 2 weeks to accept this offer, and assuming it's not an option, which we'll talk about in another podcast, I can come back to you within 3 days, 3 days later and be like, oh, by the way, Steve, I've thought about him revoking my offer. I can do that. So lapse of time is its own separate thing. It doesn't necessarily override these other events terminating the power of acceptance. Okay, on to rejection. So I make an offer to you, and in response, you reject it. I do not accept your offer. That also terminates your power of acceptance. And importantly, rejection terminates the power of acceptance upon receipt. So the good news, Steve, is if you dispatch that rejection and you decide you want to accept, you can get your acceptance there before the rejection and a contract will form. Keep in mind that you're running a big risk, Steve, if you mail your acceptance after you mail your rejection. As our listeners may recall from a prior podcast, once you dispatch a rejection, the mailbox rule is out, and a trailing acceptance better beat the rejection, because now they're both under the receipt rule, whichever's received first. But if you do a rejection, you can get an acceptance there first, and that will be effective first. So rejection, not effective until received. One of the things about, so what is and what is not a rejection? So we know a rejection is a manifestation of intention to not accept the offer. Again, okay, great. Some are easy. I reject your offer. You don't have to use the word reject. I'm not accepting your offer. I don't want that offer. When things are more ambiguous, we can have a debate now. I don't know. I'm not feeling that offer. That offer stinks. That offer stinks. I don't know. It doesn't sound like a rejection to me, but I guess it's debatable, right? That offer stinks. That offer stinks, but I accept it. We know as a grumbling acceptance, that will work. Some things that we know that might look like rejections, you might think of rejections that are not, are inquiries. Remember how we talked about an offer, an inquiry is not an offer. Would you accept $500 for your motorcycle? That's just a question. It's not an offer, because an offer is I'm ready to commit, and a question isn't committing. Same thing here. Rejection, would you be willing to accept, would you take less? Would you give me more? Asking questions about the offer. Would they make you a better offer? These are just inquiries, not considered rejections.
This is a lot to think about as a student. This is a lot to question when you read these communications in the fact pattern. There's a lot to think about. And this is where I think the typical student just blows through these facts, and whatever screams at them, they write about. But this is where you really want to sniff a little harder, because I can see a lot of students new to the law blowing through these things. This offer stinks. Well, clearly they don't want to do it, and they just sort of don't stop to question this. But this is one of those things where you really have to be receptive to what is in front of you, and the vagueness that your professor has gone to great pains to create.
And what's interesting about it is that a lot of the things that you might want to say as an offeree is you're walking a line. Maybe you don't want to reject because Steve, I like having power, and I like having the power of acceptance, and I don't want to lose it. But at the same vein, I want to express to you I'm unhappy to see if you will give me. So I don't want to do a rejection or a counter offer, because that'll terminate power of acceptance. But I want to extract from you, the offeror, a better offer. Whilst I want to have my cake and eat it too. Without making a rejection or a counter offer, I want to say stuff to you that goes right up to that line of rejection or counter offer to try to extract from you a better offer. But who knows if I've crossed the line? Only the reasonable person does, and they'll tell us later, and I don't know. So I might be saying these things where I'm trying to get right up there. This offer is terrible. I mean, I don't know that. I don't think I should say I would never take that offer. That sounds like I don't know. That sounds like a rejection to me.
Yeah, that does.
Yeah. Because I
But
would
I know what you
never, I
mean,
mean,
though.
never. I mean, that's never's never.
And that's one of those things where subjectively, they might be trying to get a better offer. Objectively, they can terminate their own power of acceptance.
Yeah, you gotta be careful, right? You slip up. Steve, I can't, it's hard for me to imagine me accepting your offer. Rejection?
I have no idea.
I don't either. Red wire, blue wire, argue both. So it is, again, it's ambiguous language. And again, that is the sort of the grist of the contract essay mill. If something's not a rejection if you indicate you're going to continue to consider it. So that's probably pretty odd. But if I say I reject your offer, but I'll think about it, I know that's who would say that? But it's not a it's not a rejection if you say you're going to continue to consider it. But that's terrible bargaining, I guess. I reject that offer, but I'll think about it. What's more common, though not very common, I think, is when the offeror says, you consider my offer, I'll give you 2 weeks. And even if you reject it within those 2 weeks, you still have 2 weeks. If the offer actually indicates that a rejection isn't going to terminate the power of acceptance, then it does not. And that makes sense, because the reason why a rejection terminates the power of acceptance is because the reasonable offeror, the offeror is going to assume that if you've rejected it, that they need to move on. You're moving on. They're going to move on. They're not going to hang around. I should look for somebody else. But if I, as the offeror, tell you you can still, accept it after rejection, well, now it wouldn't be reasonable for me to assume you're moving on, because I'm encouraging you to still think about it, and that wouldn't terminate the power of acceptance. All right, counter offer. So counter offer is treated as an implied rejection and will also terminate the power of acceptance. The theory is that if you make a counter offer, you are necessarily indicating you are not interested in or accepting the original offer. Now, you can say in a counter offer that you're still considering the original offer. I'm going to consider your offer, but but I also like to make this offer to you. That will not terminate the power of acceptance, because again, the offeror should understand that the offeree is still thinking about it. Don't move on yet. I mean, if you want to move on, fine, but you better revoke. But if you don't do that, which most of the time people don't, because it's not a great bargaining position, they just make a counter offer. I'll offer you X. Your power of acceptance is terminated. And both with rejection and counteroffer, which are both effective upon receipt by the offeror, your power of acceptance is terminated immediately upon receipt by the offeror. So even if seconds later you reconsider and then try to accept, and even though the rule that a rejection and a counteroffer terminates the power of acceptance is premised on the belief that the offeror will likely now rely upon the rejection and counteroffer and move on, even if it can be proven that the offeror did not in fact rely on the rejection or counteroffer before the offeree then made a subsequent acceptance, it doesn't matter. This is a hardline rule. It's premised on the concern about detrimental reliance by the offeror, but that is not required. The minute the rejection is received, the minute the counteroffer is received, boom, power of acceptance gone. You want the offeror to now accept, deal with you on terms of the original offer. You've got to actually get the offer to revive or renew, as we call it, their original offer, or you need to make a counteroffer, which your acceptance would be if it followed a rejection or counteroffer on the offeror's original terms. And things that are not a counteroffer, just like they're not a rejection, inquiries. So mere inquiry, we saw this with offers. It's a counteroffer is an offer. And I think students forget that. A counteroffer has all the attributes of an offer. The only difference between a counteroffer and an original offer is that a counteroffer, of course, comes after a prior offer. But a counteroffer must satisfy all the elements of a regular offer. And we know an offer is not an offer if it is a mere inquiry. Would you buy this? Would you pay $50 for this? So if I, as the offeree, say, would you buy this? I mean, would you take 50? You offer to sell it to me for 100. And I say, Steve, would you take 50 for it? A lot of students will think that is either a rejection or a counteroffer. It is not. It is a mere inquiry, and a question cannot be an offer. A question is not an offer. Not a mere question is not an offer. So that is not a counteroffer. All right. Non-occurrence of a condition. I think most professors do not teach number 6. Number 6 is when the offeror either says, I'm going to make you this offer, but if X happens, you can't accept. They put some strings are attached to the offer, and offerors, master the offer, can do that. So if I have 2 cars, one red, one blue, and I say to you, Steve, I only want to sell one of my cars and you are interested in the blue car, and I make an offer, but I tell you, if I sell my red car before you accept, you can't accept. I've made that a condition of acceptance, that I've not sold the other car. And the minute I sell the other car, you lose the power of acceptance. So to me, the non-occurrence of a condition is sort of like lapse of time, that what I can do is I can embed in my offer at the outset some protection that I want. I may know that I want, it's like an implied revocation. It's not actually revocation because I don't have to do anything. If it's embedded in the beginning, it's not a revocation. Revocations come later after the offer has been made. But it's sort of like a built-in revocation, like lapse of time is. I know that if this much time passes, I don't want to deal with this guy. I know that if this event happens, I don't want to contract with this guy. Build in any condition you want. And when that condition of acceptance doesn't occur, we say that's the non-occurrence of a condition. Power of acceptance terminates. But this is what's more common, implied conditions. So I have a house and I offer to sell you the house. An implied condition is that the house is still there at the time you accept. So the house burns down. Most people think of this as a doctrine dealing with changed circumstances, but technically when it happens after offer, before acceptance, a contract never forms. So it's not a contract forming, and then one party's performance after formation becomes impossible. No contract actually forms, because an implied condition of acceptance is that a person or thing necessary to performance still exists. So if I promise to, I make you an offer and some third party has to be alive, so I'll give you tickets to some concert or whatever, and that person dies before you accept, power of acceptance terminated. The thing is destroyed. Power of acceptance is terminated. The transaction I proposed becomes illegal. Power of acceptance is terminated.
Interesting. And so that's the dividing line is, did this happen before contract formation or after contract formation? And you go to separate doctrine. This is a big dividing line, it sounds like, for students.
Yeah, I wonder if it is, this dividing line is starting to split hairs in some respects, and that the bar examiners aren't going to be very aware of this. And a lot of law professors are not going to care very much about it. It's getting awfully technical. So I think there's a very good chance that many students, they'll never hear about this. They don't have to concern themselves with this. And this is why, is when we talk about the doctrine of impossibility and impracticability and frustration of purpose, we're actually going to see another divide, which is a lot of times these doctrines are thought of as changed circumstances. The title of the chapter in my book, I call it Changed Circumstances because it's so well known. And I got to tell you, Steve, a little bit of me died when I did that title. And I knew a little bit of me was dying. It's not like I did it and I'm like, oh, now a little bit, what did I do? I had eyes wide open. It's just so typical that when you're dealing with these doctrines of impossibility and impracticability, you're talking about changed circumstances after formation. But we actually have a doctrine called existing impracticability or existing impossibility and existing frustration. And what it seems like in the restatement is that it's the doctrine of changed circumstances, very loosely called, when you're dealing with things that existed prior to offer and after formation. And then there's this little window of when I make the offer and before you accept, these events happen, and we actually say it's the non-occurrence of a condition to acceptance and the contract doesn't even form. You know,
Yeah.
it's awfully technical,
Yeah.
but technically, yes, when it happens during that little window, the offeree loses the power of acceptance, and so no contract even forms, and you'd be dealing with the doctrine of the non-occurrence of a condition. When it's existing impracticability, existing frustration, which are topics down the road, it's very, you can argue too, a contract never forms because no duties arise. And how can you have a contract no duties arise? But technically, you're not dealing with the non-occurrence of a condition of the offer. That's for that little window between offer and acceptance.
So it sounds like for your book, you had kind of a grumbling acceptance that we're just not going to go there.
I did have a grumbling acceptance, and I'm glad that you mentioned that, because with a lot of times the counteroffer, we'd be remiss if when talking about counteroffer and rejection, we didn't talk about grumbling acceptance and bring that back in, because remember, that's that dividing line. So the flounder case, which I just taught recently in class, students love the flounder case, but they really have strong opinions, but they need to see the gray in flounder. Is that, remember, the dividing line there is this a grumbling acceptance or is this a rejection? And that was the flounder case. So he signs flounder. Is he rejecting and terminating the power of acceptance, or is he accepting but just grumbling a lot? And so a lot of times that's where you'll see this divide, is was it a rejection or was it a grumbling acceptance? And that's certainly a red wire, blue wire situation, because those are very different events. Those are not just termination of power of acceptance, but it's versus a contract forming as opposed to a rejection.
I love it. And those are the gray points. I think that's where top students learn to get a little more comfortable than average students, is seeing, okay, most confuse this with this. Let me spend some serious time refining my knowledge and understanding and my ability to analyze both of these within the same context of facts. And I think that's really what distinguishes top law students from the average.
Indeed. And let me mention something that I see that is a common mistake. We talked about the mirror image rule, and you made me think of this because you're talking about how, good students make these connections between different topics. And so much of these issues, the termination power of acceptance, do relate to issues we've talked about before with acceptance. One thing that I sometimes see, I actually see it a lot, is if somebody, the offeree, makes a counter offer. So you offer me land for $100 and I say, Steve, I'll give you 50 for it. Everyone knows that's a counter offer. A lot of times I see students argue that the response violated the mirror image rule. This is a misuse of the mirror image rule phrase. When we talk about the mirror image rule, what we mean is that a purported acceptance, an acceptance, must mirror the terms of the offer to be an acceptance. If you're talking about the mirror image rule and it potentially being violated, it's violated when, not just when somebody is proposing different terms, counteroffer, it's also when the person is purporting to accept. So I accept your offer, Steve, with the understanding that I only have to pay $50 for it, or with the understanding that you'll throw in the 3 cows that are on the land. I'm both purporting to accept and at the same time trying to change the terms of the deal. So I'm trying to have my cake and eat it too. I want to accept and trap you and have the trap be sprung, but also change the terms of the deal. That violates the mirror image rule. A clean counteroffer, where the offeree is not trying to accept and change the terms. They're straight up just making a counteroffer. I'll give you 50 for it. Don't write that violates the mirror image rule, because the offeree is not purporting to accept. That's just a straight up counteroffer. Yes, a purported acceptance, which violates the mirror image rule, is a counteroffer. But it would be strange to say that all counteroffers violate the mirror image rule, because not all counteroffers are embedded or part of a purported acceptance. So watch out about throwing around the mirror image rule Don't do it when it's just a straight up clean counteroffer. I would scratch my head and be like, that person doesn't understand what the mirror image rule is. They don't understand the mirror image rule is about a purported acceptance there, and thus being treated as a counteroffer, non-acceptance, not a clean counteroffer.
And I want to amen what you said there, because everybody's notes need to reflect not just the connections and the ambiguities between this doctrine and that doctrine, also the hard distinctions between them. If you're not looking at both, you're going to confuse yourself. You know, the law doesn't confuse you, you confuse yourself. And so when you try to distinguish all of these different doctrines, you know, try to make some hard distinctions. How is this different from that? But then how is this similar? And how could this be argued this and this? But also make those hard distinctions. And when you get into the nuance, I think it is helpful to take a step back. And can I recite from memory a one-line definition of each of these terms, just so that I understand the big picture amongst the nuance? So I'm looking for similarities, ambiguous arguments that this is this and this, but I'm also looking at those hard distinctions. I've got to do all of that. I can't just be knowledgeable about these things like I probably was in undergrad. I knew something about everything, because when you hit that level of knowledge, you will demonstrate inevitably that you are confused and that you haven't figured out the differences between these doctrines.
I would love, or maybe I don't want, I'd love you to go back to the law school me, knowing what I know now. And that's true of everything in life. But how I probably did not understand any of what you just, how I didn't get that, and so I was as lost as most, and not understanding that I should be doing those kind of things. So it is very hard. I'm just happy I'm done with law school. You're making me happy. I'm done with law school. So.
Well, I had this memory when I had been out of law school for a little bit, and I hadn't taught some of these contractual principles in years. And then I started teaching my bar course. And so I remember when I was preparing going, oh my gosh, the difference between parole evidence rule and contract modification is before and at the time of contracting, and then after contracting. And I don't know that I knew that before I was starting to prep to teach the course. And so I would tell a new law student, always do this. Ask yourself, can you tell this separate from that? If you cannot distinguish them, you need to go back and take another look. And so I've learned this from later wisdom, and this is what I bring to the coaching.
When I was studying for the bar, I still remember this. It was like, it's just, burned into my memory, where a professor was teaching. It was a little TV analog, of course, giving a talk on con law or something. And he said something about it. He said, well, so for the essay, you know what you need to do, and they don't tell you this in law school, but the key to doing well on your essays is to argue both sides. And I was like, what? You tell me this now? I'm done with law school. I had no idea, Steve. And it was so simple. Once it's just a sentence, you're just told it. Once you know it, you're like, of course, it makes so much sense, but you don't realize it until you're told, for many students, until you're told it. And so, hopefully law school is a little bit more user-friendly these days. Law is hard enough. People complain about, don't spoon feed students. Is this spoon feeding? This remains hard. Is that a rejection? Remembering all these rules. I got to tell you, I think you can tell the students, give them all the answers. I could hand them the teacher's manual to my case book. They could find it in a trash can, read it all. It's not going to make it easy. It might make it easier, but it is not, there is no like just teacher's manual where it's like all the answers are there and I got it. The truth is revealed.
And here's why, because I think we're all into a lot of these cooking shows where you get these master chefs who can make amazing meals, and they make it look easy on the TV. But don't be lulled into thinking because you eat good food, that you can turn around and make great food. It's an illusion, but I think we all feel it as we're watching a master at work. And so, you might have a wonderful contracts professor. Those of you listening who have Professor O'Gorman do have a wonderful professor. But the trick is, you don't know this like he does until you can do this for yourself. Can you draw the distinctions? Can you identify the ambiguities? Can you state the general rules and the main exceptions yourself? So you essentially have to practice making the food yourself in order to make something edible for your professor.
And when I'm asked to read other professors' contract essays like a draft, and I read it, I'm like, ooh, this is hard. I missed issues, right? I mean, I would go in and the professor, and I'm like, okay, well, this is what I saw. And they're like, well, what about this issue? Just recently, I had an exchange with a professor online, and he's like, well, yeah, but that would be unenforced under the statute of frauds. I'm like, you're right. So it's, you never end up being a computer. All right. It's always going to be hard. The question is, can it get easier? That's what you're doing. And the more you do it, the more you do what Steve is mentioning, the more you practice, it gets easier. You see more. You're never going to be 100%. There's going to be times, unfortunately, where you didn't see something and you don't know why. You do your best, but it does get, the more you do it. So we're all learning. I'm still learning. Steve, you're learning. I'm learning. That's just the way it is. And that's, of course, what I think makes law so enjoyable, is that you are always learning more stuff. So, well, shall we bring lesson number 7? Shall we terminate, Steve, this lesson?
Let's do it. I think enough time has lapsed.
The time has lapsed, which is better than some of the other things happening to us on this video. So, all right, that's it for lesson number 7. Thanks for listening to K Talk.